court. My name is Emma Poorman, appearing on behalf of the appellant, Mr. Eric Jackson. There are two claims before the court. My focus will be on my first argument, but if your honors have any questions on the second argument, I of course can answer those as well. In his motion for new trial, Jackson informed the court that a juror who also worked as a correctional officer in the jail he was being held was told Jackson that there was no way he was going to find Jackson not guilty after seeing pictures of the children in this case, and that, quote, everything else didn't matter. This same juror also did not disclose that he was friends with the victim's brother, who testified on behalf of the state, even though he was prompted to do so during jury selection. Despite this serious accusation, the trial court simply reminded Jackson that he had the opportunity to strike this juror during voir dire. By failing to investigate the juror's potential bias and to determine whether the juror fairly and impartially participated during the trial court rendered the verdict unworthy of confidence. The state argues that this issue is waived and cites Grenko, a case that concerns a sleeping juror. While we don't know exactly when this took place, the content of these remarks suggests that it happened after trial because it does. The juror did reference the ultimate verdict of guilty in this case. What's more is these remarks didn't happen in court, but in the pod, and could not be addressed in the moment the same way that a sleeping juror could. These allegations are also much more serious than simply a sleeping juror. The juror's remarks demonstrate actual malice and bias against Jackson, where he said he would certainly find him guilty regardless, and suggest he made an effort to conceal his relationship with Kenneth Austin. Also, there's no indication here that if this was raised during trial, that the court would have investigated further, because the court's remarks show that the judge misapprehended this as an issue of voir dire. The state also takes issue in their brief with the fact that Jackson didn't provide a sworn affidavit or some other supporting evidence. Again, there's no indication the court would have considered these items considering the judge's remarks about voir dire. It's unreasonable, in my view, to suggest that Jackson obtain an affidavit from the juror who was acting as his jailer, as the state suggests in their brief, confirming his own bias and misconduct. I'd also like to note that the juror's bias is not speculative. If these allegations are true, the juror expressly refused to be impartial. Also, the court denied Jackson's efforts to present witnesses at the hearing. For that reason, we ask that this court remand for a new trial in light of arguments 1 and 2, or in the alternative that this matter should be remanded for an evidentiary hearing on the factual issues raised in Jackson's motion for new trial. With that, unless your honors have any further questions, I reserve the remainder of my time.
Thank you. Mr. Williams.
May it please the court. Counsel, my name is James Ryan Williams, and it's my privilege to represent the state before this honorable court. The juror bias issue here was forfeited because the defendant failed to raise it contemporaneously, which deprived the trial court of the opportunity to investigate and cure the issue in real time, rather than only after the defendant received a unfavorable verdict.
Mr. Williams, do we know? I mean, you argue in real time, but do we know what that timing is from the record?
No, that's not made clear. He made no allegation on point.
Okay, and so let's assume that the statements were made either after the trial or after jury selection. Do you still argue that position?
Regarding forfeiture?
That it's a waive forfeiture?
Yeah, he didn't raise the issue until for the first time in the post-trial motion. So I would say that it's still, the issue is still forfeited. Moreover, I mean, he provided absolutely no cooperation for this very serious allegation. He didn't attach an affidavit from the juror, from himself, perhaps from another inmate who may have heard the statement. And then with respect to the relationship, he offered no independent evidence establishing the relationship between the witness and Kenneth Austin. Instead, he's just purely relying on his own unsworn, self-serving assertions that he only raised for the first time after being convicted of 4 counts of first-degree murder. But moreover, the evidence here was of his guilt was overwhelming. The defendant confessed his crimes to cellmate Paul Thompson, admitting that he broke into the victim's home. Things got sticky and he started a fire with a gas can. He even explained how to start a fire in a way that makes it appear that it was an electrical fire. Defendant's own brother, Codell Jackson, informed police that he went to the victim's house to beat her up and confirmed that either defendant or his accomplice possessed a gas can. Security footage captured a distinct vehicle matching defendant's Buick continually passing the scene of the crime throughout the night in question. Defendant's own cousin, Tyrone Smart, testified that defendant arrived at his house at 5 a.m., which would have been while the fire was still burning, had a strong, distinct smell of gasoline, and acted highly nervous.
Let me stop you, Mr. Williams. Does the overwhelming nature of the evidence have anything to do with the question of whether or not there was juror misconduct?
Well, assuming that this court finds that the issue is forfeited for not raising it contemporaneously with when it happened, then the overwhelming nature of the evidence would be relevant.
I'm sorry, I must have misunderstood the thrust of your argument. I thought you were saying it doesn't make any difference anyway because the evidence is overwhelming. My apologies.
No, absolutely. I'm sorry if I didn't frame it correctly, Your Honor. This is in the context of assuming that the issue was forfeited for not being properly preserved. And then if the defendant is arguing, plain error, he would not be able to establish that. And then just to briefly wrap up, of course, there's the cellular tracking data, surveillance video of him fleeing to the Alpine Inn under the alias of Corey Hinton. And of course, the fact that the police recovered a gas can from his car. So given this mountain of evidence, any failure by the trial court to conduct a deeper inquiry into the uncorroborated, unsworn, and self-serving post-verdict allegation was harmless and does not arise to the level of plain error. Unless this court has any further questions.
I see no questions. Ms. Poorman?
Thank you, Your Honor. Given the importance of the right involved to be tried in front of an impartial jury, prejudice is presumed here. That being said, I do want to acknowledge the state's arguments regarding the evidence. No direct evidence placed Jackson at the scene of the crime. He was neighbors with the victims in this case. So any footage captured of his Buick in the area doesn't really move the needle on that fact. No eyewitness identified Jackson as the offender. And there was a glaring lack of physical evidence here, no consistent theory on how the fire started. No one testified in a professional capacity about how this fire started. Regardless, this is preserved. Again, because of the contents of these remarks, the motion for a new trial was likely the first time Jackson could have raised these issues, as it likely took place after trial, although we can't say with 100% certainty. And the trial court had the full and fair opportunity to consider this information, but ultimately did not do so, dismissing it out of hand as an issue of voir dire. Additionally, I understand the state's arguments regarding a lack of cooperation. However, again, Jackson did request the opportunity to present witnesses at this hearing, and that was denied. That could have been an opportunity to corroborate this. And again, I think it's highly unlikely and unrealistic that he'd been able to obtain an affidavit from this juror alleging his own bias and misconduct when he was acting as his jailer. And with that, if the court has no further questions, we would rest on the briefs.
I have a question. What was the purpose of oral argument?
In my view, Your Honor, I wanted to make clear there were a number of discussions. There was a lot of discussion here about when this took place. I wanted to clarify those items, as well as the relevance of the evidence here in terms of how balanced it was. And for that reason, I think oral argument was something that I wanted to bring before the court's attention.
Thank you. I see no questions. Anything further from the panel?
No.
Thank you. We'll take the matter under advisement.